Hey students, welcome back to BBA Simplified by Dr. Vinky Sharma. In the process of completing this marathon class on business law, today we will be discussing Unit 4, which is on Limited Liability Partnership, and we commonly call it as LLP. In today's session, we will understand what an LLP is, how it is formed, who can become a partner, and how partners work together under the LLP Act 2008. This is a very scoring unit and also useful in real life business setups, especially for those planning to form a startup or professional partnership firm. So let's begin. The term limited liability partnership means a special form of partnership that combines two advantages. The first advantage is the flexibility of a partnership, and the other one is the limited liability of a company. According to the LLP Act 2008, an LLP is a body corporate, meaning it has its own legal identity separate from its partners, which means that the LLP can own the property, it can enter into the contracts, it can sue or be sued in its own name. The partners are not personally responsible for the firm's liabilities. Imagine there are two chartered accountants and they open a consultancy firm. They want partnership flexibility but do not want unlimited personal risk. So here an LLP is the perfect structure for them. So these key features that we had just discussed. We said that it is a separate legal entity, which means that it can own property, it can either enter into contracts. Then the second one is that it is perpetual succession. Then is limited liability of the partners. There is simple internal structure and it is suitable for professionals and small businesses. Now let's understand them one by one. When we say that it is a separate legal entity, this means that the LLP is separate from the partners. Their personal assets remains protected. The second one is perpetual succession, which means that even if partners leave or new partner join, the LLP continues without any interruption. So the succession remains the same. Then we say that there has to be minimum 2 partners. So limited liability of partners. So there is no maximum limit, but you can have 20 or even 200 partners. And when we talk about limited liability, this means that partners are liable only to the extent of their contribution. जितना जिसने contribute किया है वो उसी के लिए liable है. They are not personally responsible for the debts unless they commit a fraud. Then the next one is that there is a flexible internal structure, which means that the LLP agreement decides how the partners share their profit, their work and their responsibilities. And finally, we say that it is suitable for professionals and small businesses like lawyers, CAs, consultants, architects and even family-run businesses often prefer LLPs. So in short, LLPs offer the safety of limited liabilities and the ease of partnership. Coming on to the characteristics, they are similar to the features that we had discussed. Independent legal entity, minimum 2 partners, no maximum limit of partners. So there has to be only, the minimum is 2, but more it could be any. LLP agreement governs rights and duties of both the partners. There is a separate property from the partners. They can be, sue and be sued, and liability is limited to the agreed contribution. Now let's move on to incorporation of LLP. We will here be talking about various steps that are followed. So to start an LLP, there are certain legal steps that must be followed. So let's understand them one by one. The very first step is name reservation or run LLP. Here the partners first of all choose a unique name and get it approved through the MCA portal. The second step is filling incorporation form. We call it as FILIP. So this is the main form that contains the details about the partners, the registered office, business activities and the capital contribution from all the partners. Third one is the digital signature, DSC and DPIN for partners. So when we talk about DSC, we say that all the partners need a digital signature certificate to file the document online. And the next one is the DPIN, that is designated partner identification number. Here this means that partners who manage the LLP, they must have their DPIN. Then the next one is LLP agreement form 3. This agreement defines the rights, duties and profit sharing patterns of the partners. It must be filled within the 30 days of the incorporation. And the final state is certificate of incorporation issued by registrar. So once the registrar approves all the documents, the LLP receives its certificate and the business officially comes into existence. So these steps ensure the LLP is legally registered and is recognized by the government. Now let's see that what all documents are required for the incorporation. To incorporate an LLP, partners must submit certain documents to the registrar. They include, the first one is identity proof of partners, which includes Aadhaar card, PAN card, passport or voter ID. Then is the address proof of the partners. So it can be done by electricity bill, bank statement or any telephone bill. Then the next document is the registered office proof or any office document. So here again you need to submit the address proof of the office, the rent agreement if applicable, or no objection certificate from the owner. Then the next one is the NOC from the owner of the premises, that is again submitted as the office proof. Then is subscriber sheet or the consent of the partners. This is the confirmation or the willingness of each the partners to join the LLP. And then finally there is LLP agreement. This is the most important document. It defines the profit sharing, responsibilities, rights and duties of all the partners, exit procedure of the partners as well as included into LLP agreement. So these documents ensure the transparency and legality during the registration process. Now let's come to the third part, which talks about the eligibility and the partners, or maybe what is the eligibility to become a partner. So we say that a partner or the eligibility to become a partner includes any individual, can be Indian or a foreigner, could be any company, any LLP or any body corporate. This means that LLPs offer great flexibility. Even a company can partner with another company in the LLP form. But there are certain cases that comes under the category of non-eligibility. For example, minors are not eligible to get into LLP. Undischarged insolvents are not eligible to get into the LLP. And the persons who declare of unsound mind, even they cannot be a part of the LLP partnership. These restrictions ensure that only competent and legal capable individuals become the partners. In addition, every LLP must have at least 2 designated partners and at least one of them must be a resident of India. With that, we have understood that what is the eligibility to become a partner. Now let's talk about designated partners, an important concept under the LLP Act. An LLP must have a minimum of 2 designated partners and one of them must be a resident of India, meaning they should stay in India for at least 120 days in a year. Who are designated partners? They are responsible for the day-to-day compliance and the legal functioning of LLP. Their roles include filing annual returns, maintaining financial statements, ensuring all legal documents are submitted on time, representing the LLP during legal matters, making sure the LLP follows all MCA and government rules. So they must have a designated partners identified number, also call it as DPIN. This is similar to a DIN used by the company directors. So therefore we now understand that in simple words, designated partners are like the captains of the LLP who make sure that everything runs smoothly and legally. Now moving on to the next part of the unit, which talks about relationship of partners. We will first understand that what is a LLP agreement. The LLP agreement is a backbone of limited liability partnership. It is a legal document that defines the entire structure of the partnership. So this agreement includes the rights and duties of the partners, the profit sharing ratio, capital contribution, management roles, procedures for admission and retirement of partners, rules for dispute resolution, powers and restrictions on partners. So if partners do not create an LLP agreement, then Schedule 1 of the LLP Act 2008 automatically applies, which may not suit every business. That's why most LLPs create a customized agreement. Think of it like the constitution of the LLP. All internal functioning depends on this document only. Now let's understand the mutual rights and duties of partners under the LLP Act. The first one we say is that partners act as agents of LLP, not of each other. This is very different from a traditional partnership where partners are agents for each other. Here the partners are acting as agents only for LLP and not of each other. Second is equal rights in the management unless specified. This is again very different from the traditional partnership. Unless the LLP agreement says otherwise, all the partners have equal participations and rights. Next is the duty to maintain the true accounts. Each partner must act honestly and in the best interest of the LLP. Then is duty of loyalty and good faith. Again, each partner must be very honest to each other. And finally, no partner can transfer the role without the consent, which means that a partner cannot transfer their share or management rights without the consent of the other partners. So in essence, we understand that partners have both the rights to manage and duties to maintain the trust, honesty and accountability. Now next we are going to talk about is partners as agents. This is one of the most powerful feature of LLP. that is that every partner is an agent of the LLP but not of each other partners. So each partner is an agent of LLP and not of other partners. What does that mean? It means that if a partner enters into an agreement with a third party on behalf of the LLP, then the LLP becomes legally bound. But the individual partners are not personally bound unless they authorize this action. Let's take an example. If partner A signs a contract with a supplier on behalf of the LLP is responsible for honoring that contract and not partner B or partner C personally. However, if partner A enters into a contract outside his authority, then in that case LLP is not liable. So this protects the partners from being held responsible for each other's mistake, which is one of the biggest advantage of this LLP structure. So we say that LLP is bound by acts of the partners within their authority only. It further reduces the risk of personal liabilities for the actions of other partners. And generally here when we say actions, we are talking about the mistakes that may happen. Now let's discuss the liabilities, which is again a very important topic from the exam point of view as well. The liability of LLP. We say that LLP is responsible for all the debts and obligations. If a partner commits a wrong act during the business, the LLP is liable. So LLP is liable for wrongful acts of the partners done during the business. Then the next one we say is that the liability of the partners. Here we talk about the partners' personal liability is limited to their contribution. They cannot be forced to pay from personal assets. So partners' liability is limited to their contribution only. Personal liability arises only in case of, now there are some exceptions here. In case of fraud, if a partner commits a fraud or misrepresentation or knowingly perform wrongful acts, then that partner becomes personally liable. The liability becomes unlimited and the criminal action can be taken. So these wrongful acts knowingly committed or any misrepresentation, they all come under the category of some exceptions. So therefore we understand that LLP protects the partners but not when the act is dishonestly done. Now what are penalty for false statements? The LLP Act takes false information very seriously. So if any person or partner or designated partner knowingly files the false statement, a false document or incorrect information with the registrar, then a strict penalty is applied. Here the penalty includes imprisonment up to 2 years, fine between 1 lakh to rupees 5 lakh or both, depending on the severity of the fraud. So this clause is designed to ensure that all information provided by LLPs is transparent, accurate and truthful. It further protects the integrity of the business system and encourages ethical practices. Now let's understand a very serious provision under the LLP Act, fraudulent conduct of business. It is said that if the business of an LLP is carried out with an intention to defraud creditors or for any fraudulent purposes, then the Act imposes strict consequences. What happens in such situations? In such situations, the partners who were directly involved in the fraud and the partners who had knowledge of the fraud, they both become personally liable and their liability becomes unlimited. This means that they cannot hide behind the shield of limited liability. Additionally, civil and criminal penalties apply, which may include even the imprisonment. For example, if an LLP takes money from clients for a construction project but knowingly does not intend to deliver the work, then this becomes a fraudulent conduct and such partners lose their limited liability protection. So what happens finally? Finally, we see a winding up of LLP. Winding up simply means closing the LLP and ending the legal existence. Under LLP Act, an LLP may be wound up in two ways: voluntary winding up, or second one is compulsorily winding up. Voluntary winding up is when partners themselves mutually decide to close the LLP. And compulsory winding up is when the tribunal orders the closure due to violation of law or insolvency. Winding up actually ensures that debts are settled, liabilities are paid off, and the LLP is formally dissolved in the records of the government. So let's understand both the types of winding up in detail. The first one is the voluntary winding up. In voluntary winding up, the decision to close the LLP comes from the partners themselves. So an LLP may voluntarily wind up when the partners mutually agree to discontinue the business, when the LLP become non-operational or inactive, when the LLP unable to continue business or carry on to earn the profits, when partners want to restructure or convert into a company, and maybe when the LLP fails to comply with the statutory requirements. The process includes various steps. First is passing a resolution of winding up, then is settling all the liabilities. After that, they prepare the final accounts, and finally they do the filing with the registrar. All the documents are then further filed up with the registrar, and once the registrar approves, then only the LLP is officially dissolved. The second type is the compulsory winding up. This compulsory winding up happens when the tribunal NCLT orders the LLP must be closed. This occurs in following situations. First is when the LLP act against sovereignty of India, or there are some security of India issue comes in. Then next is LLP default in filing annual return for 5 consecutive years. Other condition could be that when LLP become insolvent or they cannot pay the debts. Also in case where LLP is formed for fraudulent purposes or any unlawful purposes. It can further be given in orders to wind up if the LLP violates the provision of the LLP Act itself and the tribunal believes that it is just and equitable to wind up. So for example, if an LLP is involved in money laundering or it fails to file the document for 5 years, then what happens that the tribunal can forcefully shut it down, and so we call it as compulsorily winding up. This protects the public and the creditors from the fraudulence or mismanaged business. Having understood all these aspects of LLP, let's quickly summarize what we have covered in this unit, and then we will also see the examination questions. In this unit, we have understood that what is LLP and what are its features. We have understood the incorporation process, the partners' eligibility and non-eligibility criteria, the relationship among the partners, how partners acts as an agent for LLP and not for each other, the penalties for false statements, and finally winding up of the procedures. So this unit is extremely important for exams and many questions are directly picked from these topics. Like define LLP, stated features, explain the process of LLP incorporation, who can become a partner in LLB, explain the relationship of partners in LLB, what is the penalty of false statement, and differentiate voluntary and compulsory winding up. Hope the concepts elaborated in the unit are clear to all of you. Thank you so much for learning with BBA Simplified by Dr. Vinky Sharma. In the next unit, we will be covering the last unit, that is negotiable instruments. Do like, share and subscribe for more marathon classes. Thank you so much for watching.